Dr. Amnugama, the Brigadier Gunasekara, the Deputy Commandant of the John Kotalabala Defense University, officers and gentlemen, Secretary to the President, Dr. Shampika Ranavakar, other distinguished guests, Dr. Han Gunratna, ladies and gentlemen. I'm not too sure whether I can continue to excite you as Gomin did. But I certainly will, and perhaps the topic that is for discussion this afternoon by me or to critique is a rather heavy one and certainly not good dessert for just after a nice lunch. But be that as it may, let me try and make it as easy and simple as possible in order to try and impress on you the constitutional revolution that Gomin seems to advocate so passionately. Now, history tells us, Doctor, that post-conflict phases always give rise to a debate on constitutional changes. There's only one point of departure that I would perhaps join issue with Gomin. I'm not too convinced with the idea that constitutional changes was the panacea for the day. We have had 18 amendments. Our constitution would nearly become a periodical if we didn't stop it. But nothing seems to have changed. Nothing seems to have changed. You can indulge in the most serious of jurisprudential gymnastics or perhaps constitutional jurisprudence without the hearts and minds of people changing. Constitutions are not meant for politicians or for lawyers or for judges to play around as a hobby. Constitutions are autochthonous, and ours is an autochthonous constitution. It grows, there is no magic in that word, it's a constitution that grows from within us, from our soil. It's our constitution. How do we give life to that constitution? It will be a dead constitution, and 18 amendments plus a constitution has not resulted much life for us as perhaps Gomin portrays it. Then what has actually gone wrong? That is because we have detached ourselves from giving life to that constitution. We read about constitution, it's nice reading, nice to listen to, but we don't get involved in that constitutional process. So it is my submission that a debate on constitutional changes actually predate the 18th of May 2009. It's much farther than that. So there has been a constant clamor, therefore, as Gomin puts it, for constitutional change. Now, what I propose to do today is to sensitize you to some issues which are engaging both public and the international community and the opinion makers with regard to constitutions. Now, having done so, I think I would probably very quickly, due to the constraints of time, let me give you a little background to, perhaps I'm sure Dr. Amnugama would bear with me, if I was to talk to you very briefly about the 13th Amendment, because there are so many misgivings about the 13th Amendment. People talk about the 13th Amendment, and I read many things about the 13th Amendment, without perhaps understanding the pith, the core, the pith and substance of that amendment. The 13th Amendment, ladies and gentlemen, bill, you will remember, it's a matter of history, went before the Supreme Court when legal counsel on behalf of the large number of petitioners argued that it required a referendum, and that is an aye from the people. And the Attorney General and lawyers on behalf of the President strenuously argued that it did not require a referendum. Now, out of 9 judges, you will remember, 4, including the Chief Justice, held that no referendum, sir, was required. Another 4 held that both bills, and that is the 13th Amendment to the Constitution and the Provincial Council's bill, required a referendum. And the remaining judge held that the 2 bills, would require a referendum, that is, we'd have to ask the people, unless 2 clauses were amended. Now, that was the pith and substance of the result of that case. Now, as such, the judgment, which was the judgment became a hallmark. It was a locus classicus, virtually on questions of constitutional law, on the whole question of devolution. Now, the main argument in that case of those who opposed the bill was that the bill was inconsistent, sir, with Article 2 of the Constitution, which proclaims Sri Lanka to be a unitary state. Now, why I think it is important is just to try and understand a unitary. We talk of unitary states, sovereign states. We are very passionate, sensitive, sentimental about these terms. A unitary state, which proclaims Sri Lanka to be a unitary state. Now, simply put, any change in this unitary status would require the consent of the people at a referendum. Why this word unitary is important is that it is so fundamental, so core to our constitutional process, that any change to the unitary character of the state, that oneness of Sri Lanka, would require a referendum. Now, the opinion of the majority of the court as set out by the Chief Justice Sarvananda, sir, was as follows. Now, this is what Justice Sarvananda said. I'll just read to you what he said. Quote, he said, the term unitary, there is no magic in this. These judgments are not meant for judges, they are meant for ordinary folk like you and I. The term unitary, he said, in Article 2 is used in contradistinction to the term federal. This is what Justice Sarvananda said. In contradistinction to the term federal. Which means, he said, an association of semi-autonomous units, a conglomerate of semi-autonomous units with a distribution, look at the important words, with a distribution of sovereign powers between the units and the center. That is what it is. A distribution of sovereign powers between the units and the center. Not a decentralization, not a giving of sovereignty, but a distribution of sovereign power between the center and the province. In a unitary state, the Chief Justice said, the national government, that's the center, is legally supreme over all other levels of government. Right up there, legally supreme. The essence, he said, of a unitary state is that the sovereignty is undivided. Let's try and understand what this is. Sovereignty is undivided. In other words, ladies and gentlemen, that the powers of the central government are unrestricted. The powers of the central government are unrestricted. It's not hampered. There's no impediment to that power. Untrammeled power. The 2 essential qualities, he said, of a unitary state, number 1, the supremacy of the central parliament, the central power, and secondly, he said, the absence of subsidiary legislative or sovereign bodies. The supreme parliament and the absence of sovereign bodies. Now, let's just look at that word a little. Now, this, of course, doesn't mean the absence of subsidiary law-making bodies. Now, sovereign bodies and law-making bodies are 2 different things. Sovereign bodies are equal. But a sovereign body and a law-making body, sir, there's a distinct difference in the 2 things. So that, he said, and he went on to say, but it does not mean, Justice Sarvananda said, that they may exist. It does mean that they can exist and can be abolished at the discretion of the central authority. In other words, the central government can at any time dissolve this lawmaking body if it so desires. Now, on the other hand, now that is a unitary unit of government. Now, let's look at a federal unit of government. Because we all talk of federalism, and why not federalism without actually knowing the first thing about federalism. Now, on the other hand, federal unit of government, as we see in India, the field of government is divided between the federal and the state government. The field of government is divided between the state, the central government, and the state government, which are, now this is what is important in this distinction, those two units are not subordinate to one another. They are equals. They are not subordinate. It's not like the center and the province. It is like the center, the central government, and then we have a federal government. But they are coordinate. They are coordinate and independent within the spheres, within the parameters which are devolved to those federal governments. So that you can see how the Supreme Court looked at the vesting of legislative and executive power and judicial power at a provincial level as they did in Sri Lanka. I hope I'm not boring you with this jurisprudential stuff, but this is something that we need to understand. And perhaps it's not difficult to understand. And we need to understand it. There's a requirement to understand it. Now, according to the Supreme Court, there was, but I can tell you very simply, the Supreme Court simply said that there was no alienation of legislative, executive, and judicial power. You know the separation of powers? The Supreme Court simply said that in this whole mechanism of devolving power to the province, there was no alienation of neither legislative or executive or judicial power. When devolution took place through the 13th Amendment, and Sri Lanka continued to be unitary, and that all that the 13th Amendment did was to devolve power on subordinate bodies, on inferior bodies such as the Provincial Council, and they are not equals. And that's how the Supreme Court actually got around the problem. Sri Lanka, they said, remained to be a unitary state. Now, this marks the principal difference between the unitary system of government and a federation. Now, when Parliament enacted the 13th Amendment on the 14th of November 1987 to introduce a constitutional structure to establish the provincial councils, the 1978 Constitution retained, therefore, its unitary status. But what did they do? They devolved power. They didn't decentralize power, they devolved power. Now, there are so many features in the 13th Amendment that demonstrates the subordinate nature, the inferior nature of a provincial council. Now, for example, ladies and gentlemen, very quickly let me take the example of the office of a governor. The office of governor. Now, under Article 154, say, you can read it leisurely when perhaps time permits, of the Constitution, the repository of executive power is the governor of the province. The repository of executive power is the governor of the province. The governor is appointed, as you know, by the President, by His Excellency the President, by warrant under his hand. Now, and he holds office during the pleasure of the President. The pleasure principle applies. He can remove him at any time. He can suspend him at any time. There is nothing that he can't perhaps do with him. Now, under Article 154, the President is empowered by a proclamation to take back the executive power and assume all the functions of the governor and assume all the functions of the administration of the province. Now, all these, what does it indicate? It simply indicates that the governor's functions as a delegate of the President exercising executive power is delegated by a central executive authority. That is simply the point. Now, and with regard to that, I can probably point out to several examples of that, and time doesn't permit me to do that. Now, this is what let me tell you what the Supreme Court again said about the legislative power of provincial councils. Now, I've told you what they said about the legislative power of the center, but let me tell you as to what they thought, what the provincial council actually, how they looked at the provincial council. This is what Justice Sharananda again said. They said, in regard to legislative power, although there is a sphere of competence defined by the two bills, both in respect of matters set out in the provincial council list and in respect of matters set out in the concurrent list, within which